Imagine that you are on a hiring committee of a top San Francisco law firm. You come across a resume from a candidate who grew up on an isolated ranch in Arizona, raised in a house without electricity or running water. The candidate worked alongside the ranch hands their entire childhood. At the age of 16, the candidate left home for Stanford University and from there had gone on to Stanford Law School, where this candidate finished third in their class. You might think to yourself, this sounds like a real American success story, a great combination of grit and intelligence. But without hesitation, you toss the resume into the wastebasket. That's a true story. The year was 1952, and the candidate was a woman, Sandra Day O'Connor, who you may know went on to be the first female to sit on the United States Supreme Court. But before 1964, you might never see a female or an African American doctor, engineer, police officer, or corporate executive. When they did get jobs, it was legal to treat them differently from white men. They could be paid less. Women could be fired for getting pregnant. After the Civil War, the country sought to protect the rights of those formerly enslaved. We call this period the United States Reconstruction from 1865 to 1877. The country began ratifying 3 constitutional amendments: the 13th Amendment, which prohibits slavery, the 14th Amendment, which gave due process and equal protection rights, and the 15th Amendment, which prohibits restrictions on the right to vote because of race or color. In addition, Congress passed the Civil Rights Act of 1866, which provides that all people born in the United States were citizens of the United States and had the same rights as white citizens. Even though we had these protections, many states and the Supreme Court upheld statutes that undermined the protections. The most notorious was the Plessy versus Ferguson case, in which the Supreme Court upheld the constitutionality of a Louisiana law that prohibited African Americans from riding in railroad cars reserved for whites. African Americans were provided with quote-unquote separate but equal cars. In 1954, a century after the Civil War, the United States Supreme Court overruled that Plessy versus Ferguson case in a landmark decision in Brown versus the Board of Education. In that case, the court ruled that the quote-unquote separate but equal policies were unconstitutional. The case itself prohibited segregation of public schools, but it was applied in any public situation from then on. So even though there is this ruling, school districts at that time were very slow to comply with the case. The Brown case inspired Martin Luther King and Rosa Parks, who held protests, boycotts, voter registration drives. These actions influenced Congress to pass the Civil Rights Act of 1964, which prohibits a wide range of discrimination, including workplace, education, voting, and public accommodations, such as movies, theaters, restaurants, etc. So in this set of videos, in this section of materials, we're going to talk about the specifically related to employment discrimination. There are decades of legal precedent or case law, administrative agency actions, state and federal legislative body created law, i.e. our statutes, restricting the ability of employers to discriminate against workers. There is a very explicit set of individuals that are collectively described as the protected class. Employers cannot discriminate on the basis of one's race, color, religion, national origin, gender, sexual orientation, age, or disability. When I say age, 40 and older, for employment discrimination. This is what we're going to be talking about here, is employment. So let's go through each one of these. Race is interpreted broadly, so it applies to ancestry or ethnic characteristics of a group of persons. For an example, Native Americans. National origin refers to a person's nationality or culture, Middle Eastern or Asian. Religion in the context of employment. Employers cannot treat employees more or less favorably based on religious beliefs or practices, and employers cannot require an employee to participate in any religious activities. Sex, gender, employers cannot advertise positions as male or female. Gender is expanded to include discrimination based on pregnancy. Gender must be irrelevant to employment decisions. That's the ruling of the Supreme Court. Sexual stereotyping is forbidden. You can't object to a woman's aggressiveness if the position requires this trait, telling a woman to be more ladylike or wear makeup or present in a certain way that isn't required of men. That would be a form of discrimination. Transgender persons are protected class under gender. The Supreme Court ruled that in 2020. Adverse employment decisions based on gender identity are forms of gender discrimination. Employers may adopt different appearance standards for men and women, but these standards may not impose a greater burden on one sex than the other. We'll talk more examples as we move forward. There are several federal statutes that prohibit employment discrimination against members of the protected class. Many we're going to discuss, but I will note many states have their own laws that protect employees against discrimination, including New York. New York has tougher rules on discrimination. There's a larger net of a protected class. They include some different ones. They include military status. They actually specify gender identity or expression, sexual orientation, marital status, status as a victim of domestic violence, arrest record or conviction is also one that's noted as a protected class. New York also has a law that they call the Crown Act, which bans employers and schools from discriminating against hair textures and styles. We have discrimination from harassment or a continued pattern of unwelcome behavior from anyone in the workplace based on these protected classes. It is the Attorney General's office. They have a Civil Rights Bureau, and there's also the Division of Human Rights Commission. Both of these bodies will enforce the discrimination rules.